Speaker.
Dennis O'Rourke.
Thank you, Mr. Speaker. The first thing that I ask myself about this bill is why David Bennett decided to sponsor it. Could it possibly be that he intends to go to live overseas permanently and wants to prepare the ground for that? Could that be the reason? If so, that in itself would be a very good reason for supporting the bill. Could it be that there is such huge pressure from his constituents in the Waikato that this bill be passed that he couldn't resist it? Could that be the case? Somehow I doubt that very much. Or could it be that Mr. Bennett is looking for a legacy bill, something that he can say to his grandchildren, this is something, the only thing probably, but something that I did when I was in Parliament? Could that be the motivation? Somehow again, I doubt whether it would be satisfactory as a legacy bill, Mr. Speaker. Could I say next that I also have had only a little experience with what I used to call the conflict of laws, and that was in my early years as a lawyer in the Public Trust Office where I had to deal with the conflict of laws around testamentary law. And I remember very distinctly the difficulties that arose when people who lived in New Zealand still had a domicile of origin overseas, and there was therefore, and they'd made a will in New Zealand, and there were difficulties because English common law and New Zealand statute law are quite different than the Code Napoleon, which applied through most of Europe, where I remember one case in particular, the deceased person lived. Very, very difficult situations to deal with. Quite different from the law of torts, but also very difficult. Now, Mr. Speaker, New Zealand First will not be supporting this bill, even though we accept that the current law is far from perfect. And we're not doing so because we don't really think that there is any particular need to abolish the current law as it applies and as it is proposed to abolish in this bill. Mr. Speaker, we're not satisfied that the existing common law rules around the conflicts of laws and the application of the law of torts of one jurisdiction or another is actually necessary, and we would have to be persuaded yet that that would be the case. The third reason that I want to give for not supporting this, apart from the fact that it's not needed, apart from the fact that there is no requirement for this, there's no pressure for this. The third reason is that we are concerned about clause 8.1, which displaces the general rule, and Mr. Parker has already pointed to the fact that it introduces a new test, and I quote from the latter part of clause 8, where it refers to that it is substantially more appropriate for the applicable law and so on to apply. And the concern we have about that is that we are not sure in what circumstances it would be substantially more appropriate or not. And that is a discretion that the court would have to exercise. I don't know how they would exercise that discretion. I would like to hear discussion about that and how that test would work in practice. So I think that's too general, that's not specific enough and doesn't actually achieve a sufficiently robust new regime to justify the abolition of the current law which has been developed over such a long period of time. Now, overall, this bill does have some merit because it does deal with that difficult issue of double actionability. But we think in New Zealand First that the solutions which are provided in this bill are not necessarily the best. So for those reasons, Mr. Speaker, we will be voting against the bill. But on the other hand, I will certainly be interested at the Select Committee to listen to the arguments which will no doubt be put forward to justify the bill which we have before us today. For the time being, however, New Zealand First will be voting against.
Mr. Speaker.